that changes the nature and the purpose of the trust. So let's start back when Adam and Eve were little kids. So Rome had trust, but it came about kind of as a workaround. Their trust, they had a system to transfer property on death, but the trust was not part of it. And they came up with this fideicomiso, and it was basically probably a lawyer's workaround to keep from getting their property confiscated. And they would appoint someone as trustee, but the trust that in Rome was more like a will because it only spoke at death. And the Romans believed that personal immortality went with the assets they sent. So I think that's good. Maybe, hopefully that happens here. I made a note that fideicomiso is the Spanish word for trust. And you don't see it too often, but in Mexico, they have a trust when you try to buy real property near the coast. The Mexican Constitution does not allow foreign ownership. So they get a bank to be a trustee, you buy the property, and the bank holds title for 99 years. And then if you're around, well, then you can renew it another 99. So another evolution of trust was from England. Since we adopted English law, the Franciscan friars had a vow of poverty, so they couldn't own any property. And the kings evidently were kind of erratic on taking things, and they decided to have the local municipality own or a trust be created, and that allowed the friars not to have any property showing in their name. And then other well-to-do people, landed gentry, started using the trust, but they had quite a lot of problem with, the king got mad at somebody for treason, crimes, failure to do military, and then they would just come in and take the property. So it came about, the term common law means that it was derived by court cases. It was not a statute that started it. So the attorneys of the day started doing these trusts, and then they got in the courts, and then they became more accepted. And it wasn't until quite a long time later where they were actually codified in a statute. Some background on the law. Common law is what we have, and what that means is we have stare decisis, that court cases have effect. And the other type of system is civil law, like France, Germany, Spain, and it's just the statute. Every time they go to trial, they have nothing else to look at but the statute. And the reason why this is relevant to trust is that common law jurisdictions have trusts. Civil law jurisdictions do not have trusts. They are not part of their legal system. They don't know how to handle them. And so if, for example, you wanted a trust and you lived in Germany, well, you can't have a trust. And there is none. So what people do in Germany is, since there's none in the country, they'll go to some place like Liechtenstein, and there's another device called a Stiftung that is ended up used like a trust. So there's a workaround in that. Then we have a different evolution of the courts, and this historical court evolution is still with us. The English law allowed for a court of equity. So when the person uses the term a court of equity, it means that they've got, the judge has, or the jury has a decision to make non-monetary decisions. So that's where they call it equitable. Another way to say it would be fair. And so the probate court today is a court of equity, but it also has the right to do the other part. The court of law was determine monetary damages. And in Britain, they use the term chancery. I guess you die and make a estate plan and take your chances and see if it follows through. But the United States had that wording for a while, and it's pretty much gone. But the probate division in California would be considered an equity court. Okay, back in 1965, a book came out, Norman Dacey, about estate planning. It was a do-it-yourself, I think long before anybody heard about Solo Press. And he wanted to let everybody do their own trust. And so he had do-it-yourself. He had about 51 pages of advice, and then quite a few tear-out forms and things where you can put your own trust together. He was not actually what you'd call complimentary to lawyers. He objected to them and high fees. And at the time, in the old days, attorneys used to do wills all the time. And they would have a portfolio of wills. And by natural attrition, some of those estate plans would come to pass because the person would pass away. So that was an old process that did take place. I remember when I was a young kid living in Walnut Creek, and my dad had the book. He was reading it and working through it. He was trying to take care of his family and avoid probate. And he ended up setting up his own trust at that point. Later, it was amended. He passed away in '91, and then I wonder, there's another screen that has a microphone going, and it's causing some feedback. Anyway, this Dacey book allowed people to do their own trusts, and the attorneys didn't like it. It was taken to court by the American Bar Association, Connecticut, Florida. The attorneys thought that he was encroaching in their bailiwick. I don't know if they were considering free speech or not, but seems like there's some factor in that. But one of the objections the legal community had against the book was there's 50 states, and his book did not give any distinction between different states. So my dad was adamant he wanted to avoid probate, and so he did. And later on, he died earlier. Then my mom passed away about 3 or 4 years ago, and her trust. And just before she died, my sister snuck in and had herself put on as trustee, and she was the trustee after my mom's passing. And then she proceeded to clean out the cookie jar and took hundreds of thousands of dollars. And my dad's goal of avoiding probate came to fruition. There was no probate. Okay. But the rogue trustee stole way more money than it would have cost to do a probate. So it was a false economy. And I see a lot of attorneys, they just tout trust, trust, trust. It's not all that simple. And everybody I know has a story about someone they know that lost a bunch of money because of a dishonest trustee. So it's just something to keep in mind that trusts are not the end all be all save all. Every so often you see these ads in the newspaper or the radio where they're going to have a free dinner, come down to Holiday Inn or Marriott, and we're going to talk about trusts, and they end up calling those trust mills. The state bar has had a program about those for many years, and this text came from the California Attorney General, who prosecutes the cases. One of the things I learned about these trust mills is they'll give a big promotion like trying to get a bunch of trusts going, and they'll charge $490. I didn't know why. Well, it turned out that $500 and above at the time was a felony. So they would, a lot of them are like annuity salesmen, and all they really wanted to do is give somebody a generic trust and then get their financial data and tell them how bad their investments are, and then sell them annuities. And I hate annuities. They take my clients' cash and guaranteed. Oh yeah, and the insurance company makes all the money on it. So the Attorney General has different suggestions you can read there about verifying who you're dealing with, check their credentials. And then I noticed this third to last line, it does not say anything derogatory. It just says LDAs, legal document assistants, are not permitted to give legal advice, and paralegals must work under the direct supervision of a lawyer. Okay, it's just a statement of fact, and why they put it there, I have no idea. But they say if you get victimized by one of these trust mills, to contact the district attorney. I have amended trusts that came from the trust mills, and my view was that they were pretty bad. They really didn't do what the client wanted and didn't do what the document was supposed to do. So, back on the ground, who are we dealing with here? Settlor creates a trust. I like the word grantor because dealing with clients, they don't get thrown off by the word grantor. They can get that. A trust creator or trust maker. Most people in the trade call them settlor. They're not settlers. Those are people that came across the country in covered wagons. There's another letter in there. But people who want to create a trust. So people imagine what kind of distribution they want, who they want to get their stuff. And frequently couples create their trusts together. It doesn't have to be human. You can have a legal entity form a trust. And some prohibitions, a minor cannot create a trust, nor can a minor receive a bequest of more than about $2,500 without supervision of a guardian. And frequently in probate, we have funds for guardians in a blocked account, and I thought that was dumb. They've got a parent. And then I found out the courts were concerned because sometimes the parents would take the kids' money and spend it. So I go, oh, okay, I get it. But if you have an incompetent individual who needs a trust, and it's quite common because of Alzheimer's, what needs to be done is prepare and file a petition for substituted judgment. And what that is you bring the situation to the court and say, Your Honor, this person's not capable of creating their own estate plan. This is what we think they would want, and this is a natural distribution plan. And then if the judge signs off on it, then you are successful and the person ends up having the trust or estate plan. Trustees. basically the trustees end up owning bare legal title to whatever property. And it sounds kind of scary, but they are in fact listed as the owner. And normally the trusts that we see, husband and wife are the initial trustees. One passes away, the other continues on. And when the second spouse dies, then the successor trustee takes over if they want to. Sometimes they don't. And then you have to go to the alternate. But one thing you need to make sure in all your documents, we've had to go to court before because the woman made a trust, named a person to be the trustee and no alternate. And then the settlor grantor died, and then the successor trustee did nothing. And then the successor trustee died before any trust administration. So we came along 15 years later, filed a petition to get a daughter to be trustee. So always have a way to get another trustee. And when you're dealing with families who are administering a trust, I find there's a common misconception that trust administration and beneficiaries have democracy rights. Now, and it doesn't really matter what all the 5 beneficiaries vote. You have to follow the trust and California law if it supersedes it. Beneficiaries, we all know who they are. They're the ones that get the benefits of the trust. And it can be alternate beneficiaries or various systems that can be developed. Okay, the question comes up when sometimes when you get these online trusts or these trust mills, people will pay the whatever it costs for the trust, and then the person dies and they find out they never titled any assets in the name of the trust. So the trust was worthless. It didn't do what it was supposed to do, but yes, they had a trust, but everything has to go into probate. And currently, if you have assets out of a trust and your estate has more than $166,250 in value, then that's the requirement level where you need to file a probate. So the main one, when we're doing estate planning, we won't let the estate plan, it's not done until we record a deed, a trust transfer deed in the name of the trust and our clients as the trustees of that revocable trust. And a lot of these trusts are called revocable trusts. Well, you can't change that name. So we're doing trust administration on these trusts that have been irrevocable for quite a long time, but the name always says revocable. So when you're drafting trusts, I would leave that word out and just call it a trust. And frequently, we don't even use the client's name in a trust. It's kind of regimented that you use their first and last name and initials and everything else. And I think that's a waste of time, and it's tougher on the successor trustee because they got to write out 6 different names or more as the name of the trust. It doesn't seem like there's any need for that. Things that I don't recommend people put in the trust, things registered with a DMV. We've had the experience, somebody goes to try to register a vehicle in the name of the trust, and they go to the DMV window and they say, oh, you're transferring it to a trust. We have to send you over to the Department of Tax and Fees to make sure that there's no sales tax, because we want to make sure we get all the sales tax we can get. And then the person goes over to the Department of Tax and Fees, another, procedure, and then they get a clearance, there's no sales tax, then they go back and register it. But it's actually easier if you don't put it in the trust, because there's an affidavit procedure excuse me, using a DMV form where you bring in a certified copy of the death certificate and you sign under penalty of perjury, you're the rightful heir to this asset, and they give you title to the property. You know, I kind of concerned sometimes, you know, maybe somebody comes down and there's an expensive car, they get a death certificate and just take the title, but DMV seems to be okay with it. And other things, mobile homes, there's a state agency that handles those. Boats, we usually don't register those in the name of the trust. We transfer in the trust by a declaration of transfer of personal property to the trust. And since there's no real property in the vehicles, that is usually sufficient. Other items you don't put in a trust: IRA accounts, 401ks, other types of pensions, and another one are annuities. And one of the reasons you don't put them in a trust is that they are already trusts. So when you have an IRA account, for example, you're the beneficiary, supposedly, and the bank or brokerage firm is the trustee. And then you have this beneficiary declaration that they go by, and it's based on contract, and it avoids probate. There's no probate on those assets. And once in a while, I'll have a client that wants to put their IRA in the trust. And I recommend it because, for example, you can, survivors, individuals can do rollovers and other tax choices. But when you direct the retirement account to go to your trust, you lose all those tax options. So that's something I would avoid if you can. The basic trust pattern is the trustees create the trust. They're really the grantor settlors. They create the trust, and they name themselves as trustee because they don't really want to give up control of their property yet. And it identifies the beneficiaries, and then they start titling the assets in the name of the trust. We use what's called a revocable trust, and there's a reason for it. One of which, it's a disregarded entity. By that I mean there's no federal ID number, no tax reporting. It all goes on the individual's tax return, like always. And it can be amended up until the death of the second spouse to die. But a lot of people don't realize you can put in clauses. We put in clauses that allow, excuse me, I dropped something, that allow amendment for a trust after death. And there was a reason we did it, and it went to litigation. There's no law that says you have to make it revocable after death. But in order to do what we're trying to do with estate planning, we want it light and easy and allow the people to change and put in, change the terms of their trust. So I think the arrows are going the wrong way, but we have Grandpa Got Rocks. He's going to set up a trust, gets a trustee to manage it for the beneficiaries, and you can put virtually any kind of asset into the trust, tangible and intangible. And I don't know if any of the participants here have worked with beneficiaries. We do trust administration, and we've kind of come across some humorous things that we think that beneficiaries usually have one thing in mind, and that is, when do I get my money? And they don't realize that there are legal procedures that need to get followed, and oftentimes they're hammering on the trustee. What's taking so long? What's taking so long? We had one administration that had 50 beneficiaries, and the beneficiaries kept trying to call our office, but we can't talk to them because we represent the trustee. But basically, if you're administering a trust, the trustee needs to talk to them. And I do recommend wide open communication with the trustee beneficiaries, because when they don't hear anything from the trustee, they always think something's wrong. And but we make light of it, but we call it the beneficiary song. That these, when do I get my money? When do I get my money? They keep singing that over and over again. So, but there's a bit of truth in it. Okay, this is a common trust. Most people call it a married couple trust without an AV trust. I have a nickname for it. I call it the I Love You Trust. So there's no bypass trust, which means no second trust is created on the death of the first settlor to pass. And the trust stays revocable after the first death. And usually the surviving spouse remains as the sole trustee and has unfettered discretion with all of the assets administration of the trust. This graph kind of implies that you transfer your debts entitled to the trust, which we don't usually bother doing. The creditors usually figure out how to get their money. And but that's a simple flow chart of an I Love You trust. And I would only recommend it if the family, long-term marriage, and only children from that marriage. Because when you start getting into blended families, you have beneficiaries from other prior marriages, and we've seen cases where there's been problems for the deceased spouse's children. So, the ubiquitous bypass trust. This was a result of people trying to get out of inheritance tax. So what happens is you have all this property for the family, husband and wife, and it's a combination usually of mostly community property, maybe some separate property. And people can acquire separate property before marriage or by inheritance during marriage. Then I look at it kind of like a ball of assets. And then when the first spouse dies, that ball breaks in the middle. And it technically does create two different things. Half of the community property of the decedent and all of the separate property of decedent are in one division. And the surviving spouse the same, half of their community property and all their separate property. And what came to pass was they found out that if these trusts took the first spouse to die, put it in a separate trust, it kept it out of the surviving spouse, so they wouldn't have to pay inheritance tax. And it worked. And the surviving spouse is always worried that they're not going to be able to get any money out of that trust. And that's not true. The surviving spouse can, what they call invade principal, on this ascertainable standard that is for health, education, maintenance, and support. What does that mean? Well, to support their lifestyle they become accustomed to. So if they normally just went up to Tahoe for vacations and led a frugal life. And then the first spouse passes away, and the survivor goes on African safaris or trips around the world. That's not what the person was accustomed to, and that might not be permitted within the trust. These words, health, education, maintenance, and support, came from court cases that the IRS lost for.
Sorry, I got to interrupt you for 1 minute.
Okay.
Kathy's computer froze and she's the host and she can't get back in. So I need you to pause for 1 minute.
Okay.
I need to let her in. You can tell them what.
Okay, so we have a technical problem, and that is Kathy Herzog's computer broke down for a second, and she was the mistress of ceremonies, and we're trying to get her back in the meeting so she can do her job.
She should be here. I'm gonna unmute her though.
Yeah, unmute her. She doesn't talk that much anyway. Yeah, okay. While you're doing that, I can talk. I'm not doing that.
Oh, yeah.
So another aspect of the bypass trust, if you've been around them, is they are irrevocable. And the term irrevocable, I want to make that clear. People misunderstand it. They think revocable means nobody can revoke it. But in reality, the law says only the settlor cannot revoke it. You can give the right to someone else, and you retain the right within the trust to revoke an irrevocable trust, but the assets are not supposed to go back to the settlor who created it. The other thing that happens when a revocable trust becomes irrevocable is now that it's a taxpayer entity, because you can't use a decedent's social security number anymore for any purpose. So we end up going to IRS and getting a taxpayer identification number online for the trust. And that's going to be required because if the trust has income over $600, then they're going to have to file a fiduciary tax return, a Form 1041. And it's common. I'll talk about it more later, but there are a lot of existing bypass trusts that are around, and they're not really serving the purpose they were intended, because the inheritance tax threshold above which you pay inheritance tax, estate tax, has gotten so sky high that very few people are paying estate tax. So if you're learning, excuse me, I had the Kremlin on the line. The memory aid for the AB trust is A stands for above ground and B stands for below ground. Some people use different terms, but that one seems to stick. And when we're creating the bypass trust, and for a real property deed or something, we will call it the B trust because most people will know what it is. Okay, so what do we have here? AB trust, we have it split on the first death, and then it goes to the beneficiaries. And the bypass trust does not go into the estate of the surviving spouse. So the idea is now it's split, there's going to be less inheritance tax. True. But there's something with the bypass trust when the assets are sold is step up in basis. Now, base is a tax term where it's what you use to figure your gain or loss. So if somebody bought a house for $20,000 60 years ago, and when they passed away, it was worth $1 million, then if that was in the bypass trust, which is not, it shouldn't be there, then the basis gets stepped up to market value. So if the trust or the beneficiary sold the property tomorrow, they would not pay inheritance tax. But one of the problems with a bypass trust is that the property gets a step up in basis on the death of the first spouse to die, not the second one. And so if the second spouse to die is 30 years later, there still may be a low basis, but you can look into that more. It's section 1014 of the Internal Revenue Code, which I'm sure you all have with indexed and everything, likely not.
Rex, excuse me for just a second.
Yes.
This is Kathy. My computer went down, so I am back on. So if any, I don't have any chat. So if anybody wants to resend their questions, if they could please do it, and then we'll get some questions and then I can ask you.
Sharon, do we have the chat?
I have the chat. So Kathy, I'll just copy it and repaste it for you.
Okay, that's good. Thank you.
Yeah, on my screen, I've got questions going back to 6:01 p.m.
Yeah, they were talking about,
Yeah.
oh, probably it starts about, I don't have any idea. But people can just resend. I mean, they can hear us, they just can't talk.
Okay. So anyway, there's a lot of details with the AB trust, and there's more administration. It's fairly common, but now you don't have to pay inheritance tax unless one of the spouses has over $11.58 million. And you figure $22 million for a couple. So a lot of these AB trusts that were created a long time ago, when you started paying inheritance tax over $675,000, these AB trusts are worthless. And I run into them fairly frequently. Somebody has a 20, 30-year-old trust and it requires a splitting. Well, it's a complete waste of money. They're not going to pay inheritance tax. The tax rule changed. They didn't update their trust. They need to. And you try to get it out of the trust so that it doesn't create more expenses for their surviving spouse. What is happening in place of it is the same result, but it's called a disclaimer trust. And we'll talk about that, where the beneficiary or surviving spouse says, no, I don't want it. I'm not going to take the request, and it goes over their head, and then it creates the second trust. Okay, so now we're talking about the blended family. So you have children from prior marriages. This one I'm very concerned about, because I've seen it where a surviving spouse wasn't very fair to the children of the deceased spouse. It just irritates me. It's just not right. So when we have a blended family, we don't usually use the simple trust, the I love you trust, that nothing happens on the first death. We suggest that they get a required AB trust to protect the deceased spouse's children. And just to make it more interesting for the surviving spouse, I always try to put on a beneficiary from the deceased spouse's kids, and that creates oversight, so the assets are not wasted or disappeared. Okay, so we have deceased spouse and irrevocable trust. Put one of the deceased spouse children on. Another problem with the AB trust for the surviving spouse, even if it's irrevocable, is we came across the case where the surviving spouse had one daughter and the husband, we always kill the husband off first anyway, and he had two children, and the surviving spouse went and got a reverse mortgage, pulled out a bunch of money from the bypass trust, gave that money to her daughter, thereby ripping off the kids of the deceased spouse. So you might, in your trust documents, consider some wording to prevent that type of thing from happening. This is a disclaimer. So the scenario is there's an AB trust, the assets have split in half, the deceased spouse's assets are to be given to the surviving spouse, let's say, and the surviving spouse says, I don't want it. And then if you have a disclaimer trust, the wording says, if the surviving spouse disclaims, then the property goes to a bypass trust. So it is the same thing as an AB trust, only it's purely optional. So if your assets grow more than $22 million, which is only 1% of the population, then you can use the disclaimer trust. And disclaimer is defined in Internal Revenue Code section 2518, but it says, basically the surviving spouse says, I'm not going to accept the gift, puts it in writing, has to give that to the trustee or verify it with the beneficiaries within 9 months of the date of death. And during the interim, the surviving spouse cannot have taken any dividends or income or use of that property for the disclaimer to work.
Hi, it's Kathy again. Maybe since you can't cut and paste. Oh.
I'm not sure if I have a question or not, but some creative uses for a bypass trust, a disclaimer, I mean. You can have separate trusts created for each beneficiary. And you could create a pot trust, which is for many beneficiaries in one pooled trust. You can create in a bypass trust situation a standby special needs trust for people getting government benefits. And you can also create asset protection trusts if a person has addiction problems or creditor problems. So there's a lot of possibilities that can be done with the trust. Now, we talked about a few.
I'm gonna be asking the questions because she still can't, but I'm on this mic and I need to read them from my screen and ask you the questions.
I stay here.
Turn on your things like.
Oh, I got you. Okay, so we're getting it worked out because avoiding problems. Tamara Brown, my paralegal assistant and LDA, is going to be reading the questions to me over our walkie-talkie. And because I think that's a workaround that we're going to be doing. So back on the 31 flavors of trust, I compiled. Oh, here comes the question now.
Okay, this is from Lisa G. She says, we are grown adults and we have trouble with Zoom. Yes. Not a question. Okay, next question. If a property has homestead, does that still apply when the property is put in trust?
Okay, a homestead in California, it's not widely used. You can, my understanding is it exists without filing, but there are some forms to file. Most creditors don't usually take the house, but it's not really relevant because when you transfer a house into trust, you leave all the liens and prior loans and all the other things into the trust. You leave it on the property. And a revocable trust is a non-entity. So it does not impact anything other than you just put it from your name to your name as trustee of your trust. So don't worry about homestead.
Okay, next question. What about putting the trust as a contingent beneficiary on the IRAs or pensions and bank accounts?
Okay, I'll repeat the question. I had mentioned not putting the beneficiary on the IRAs and pensions towards the trust. The question is, what about a contingent beneficiary? Yes, that's a good plan. So if you have one beneficiary or two or whatever, and they're not alive at the time of the distribution, and you still want to have it managed by the trust, fine. I think that's a good thing to consider.
Okay, next question. Is it smart to just list the IRAs and 401k on the trust schedule so that beneficiaries know certain amounts exist, but then not funded?
Okay, the question is, what we're talking about assets that are not going to be owned by the trust, and the Schedule A, which is normally the list of assets at the end of the trust. We will frequently put those in, and we'll put a heading above it saying that we're not intending or implying that these assets are owned by the trust. They're going to transfer from beneficiary statements. And by talking about beneficiary statements, it's a good idea to verify your client's beneficiary statements. I had a client, and husband and wife, in my office, and I had a statement from the pension, the beneficiary statement, and the wife hadn't looked at it. I looked at it and I go, "Who's Joe?" And husband and wife look at each other, and the wife turned red and said, oh dear, that was the man I was seeing after I was divorced before I met you. And that long gone guy was still the beneficiary on that account. So the moral of this story, if it's moral, is check all your beneficiary statements and it'll be better. Okay, what other
Next
question?
What about if a client wants to put life insurance in the trust so that bills are paid first, and then they want the rest to go to the beneficiary, but don't want the beneficiary all at once?
Okay, yeah, there is a life insurance trust, but that's for inheritance tax purpose. I don't see any problem with that. Having the funds go into a trust and managed, and then the residual going to the beneficiary, I think it's a fine idea. Life insurance is not taxable when you receive it, unless you had life insurance, like say for a buy-sell agreement in a business, and you deducted the life insurance on your taxes. That's a problem, because when the life insurance pays off, now it's taxable. But the majority of the time, that's not a factor. So yes, life insurance going to a trust is fine.
One thing I wanted to clarify is there was a few answers on here that says a trust cannot be revocable after death. The trustee is anyone. The trust becomes irrevocable upon death. And in most cases, I would say yes, that is true. But we have some cases where the initial beneficiary is given the right to amend the trust, and or I know that a court or a judge can amend the trust. So even though it is irrevocable, it's really not irrevocable.
But it's not irrevocable because of law, because an original trustee allows for successors, and the successors can be given the right to amend after death. And then there's another concept called trust protector, who's not an active manager trustee, but they kind of stand back like a guardian angel and are given certain powers. But We had one where it was litigated. We had a rush trust with a lot of assets, and I made it amendable after death because we did not have time to make the full trust. We got it, the abbreviated trust, done 24 hours before, and he died after he signed it. So, and we needed to put more things in the trust, but didn't have time. And it was litigated. Nobody unraveled that after death amendment. But that's kind of unusual. Just assume that it's irrevocable, and that's the best, unless you have some other reason.
I have a couple more, so I'll go quick.
Okay.
So do you suggest setting up the EIN number when you prepare the trust or after the death?
Okay, yeah, the employer identification number, we're talking about a bypass trust where, or it could be an I Love You trust on the second death. Don't bother getting it before death because the trust being revocable, another term you'll run across is grantor trust. And what that terminology means from an IRS standpoint is it's a disregarded entity. You still use your Social Security numbers, but you should not get a new identification number for a trust while the settlors are alive, because the IRS, when they give you the ID number, about the third paragraph in on the letter with the new ID number, says, we're expecting a fiduciary tax return, Form 1041, next April 15th. And so the answer is no. Wait till there's no other settlors alive.
Okay, can kids or guardianship of kids be included in a trust?
Okay, kids can be included in a trust, but there's a severe limitation on kids in receiving assets. You cannot make a distribution to kids if they're under 18, above 2,500. It's prohibited. So you have to give it to a guardian, or you can put it in a Uniform Gift to Minors Act account. And then you don't necessarily have to have the parent be in charge of the funds, whoever is responsible. And oftentimes what happens in the trust, there's wording that says, if any of the beneficiaries are under 18 at the time of the distribution is going to be held until they become of age and then be distributed. But
Okay.
Go ahead.
That's good enough. Okay, what if the trustor is not a U.S. citizen or just a resident, or if just husband is a U.S. citizen and the wife is not? Or what if the chosen successor trustee is not a U.S. citizen?
Okay, I'll take the last one first. If you appoint a trustee who's not a U.S. citizen or doesn't live in the country, you have just created a foreign trust and a whole lot of paperwork. Don't do it. Have a U.S. person be the trustee. Now, the issue that you brought up, husband and wife, and one's not a citizen, is huge. Because, as I mentioned, for a single person, $11,580,000 before you pay inheritance tax. Husband and wife, it's double that. If you have a non-citizen spouse as the surviving spouse, you pay inheritance tax when the assets exceed $158,000. So you're almost guaranteed to have inheritance tax. And it was designed because a lot of the non-citizen surviving spouses would get the money and go back home, and IRS, they'd never see the money and couldn't deal with it. So what you have to do is create a certain kind of trust. We have it in the material. It's a qualified domestic trust, QDOT, and it must have a U.S. trustee. And you don't really get out of the inheritance tax because you just don't pay it when you put that money in it, a QDOT. But every distribution to the surviving spouse who's non-citizen is inheritance tax. So it's only just delayed. But you can do things like the surviving spouse hurry up and get a citizenship.
Into this. We're gonna let you go ahead and finish your slide, and then I'll ask you.
Okay, but it's 7 o'clock, so we have a bunch of slides. These are different types of trust. Inter vivos is what we do between living people. There's testamentary trust that you kind of think it's a ripoff because you have a trust and then you go to probate and it creates the trust. But there are times when it's useful. If there's no other family members around and a minor, and you want the court to supervise the money. Okay, revocable trust, as I mentioned, it's only the settlor who cannot revoke it. To be, correction, I said it backwards. It's the settlor can revoke it and get their assets back. Anything with a trust, if you have community property or separate property, you put it in a trust. Then you revoke the trust and it comes out as the same character of property, separate or community. This is huge. Anybody that becomes incapacitated and goes to an assisted living facility who does not have an estate plan and they're getting Medi-Cal has a huge problem, because after January 1, 2017, if your estate goes to probate on a will, Medi-Cal will recover, quote, recover the money they gave you. It's also called clawback. And it's only if you do not have a trust. So if somebody goes to a care home, they're paying the $5,000 a month for their overhead, and they don't have a trust, and let's say they're not competent, what needs to be done is they need to be brought to court to get a petition for substituted judgment to get their property in a trust. Then when they pass away, Medi-Cal cannot recover the money and take it away from the beneficiaries. Marital deduction trust, that's pretty much, let me say something about inheritance tax. When you're doing estate planning and you start talking about inheritance tax, there's a whole lot to learn about it and a lot of procedures. But if you don't have, or your clients don't have, over 11 million for one person or over 22 million for a couple, inheritance tax is not going to happen. So what I suggest is don't spend any time learning it or dealing with it, because you're not going to have it. And it just avoids a lot of unnecessary complications, and a Q-tip trust is like that. I'm not going to explain it, it's too complicated. Special needs trust is quite useful when you have a disabled person, adult or minor, and they're getting needs-based public assistance. If they get an inheritance, the government will say, okay, you got money, we're cutting you out of the program, and you got to burn through your money, they call it spend down, before you can go back on that program. And then after you run out of money, you got to apply again. It's bad. So you should not bequest money to a special needs person who can't care for themselves. If they're on public assistance, you do it in a special needs trust. And this is also a concept for asset protection trust, where it's called a third party created. So in this case, let's take mother and child. The mother creates a special needs trust for a child who's developmentally disabled and is on public assistance. So the mother is the third party, the kid didn't create their own trust. And the other requirement is that there's discretionary distributions. So the distributions can be made in the judgment of the trustee, but they're not required. And that stops creditor claims too. And the payments that are made, like for it can't be for food or board, but the special needs trust can pay for other comfort items, vacations, different things. There's a list, but a special needs trust is very useful. And you can create it right away and fund it, or put it in a trust when the second spouse dies. Sprinkling trust, trustee gets to make up their mind who gets what. A special purpose trust is for some cause that you're concerned about. The term grantor trust means a trust that is non-existent for tax purposes. So it's a big deal because you don't want to be subject to tax. Dynasty trust is a trust where people with a lot of assets want to keep it in trust for multiple generations, like the Rockefeller Foundation or something like that. Insurance trust, I'm going to skip everything that has to do with inheritance tax. That's it. Qualified personal residence trust at Cupert. This is an interesting trust for asset protection. So you create a trust and you're going to live in it for, let's say, 15 years. And at the end, it's going to go to your beneficiaries. And it's irrevocable. And it stays out of your state. It can't be invaded for creditors and things like that. And then after the time passes and you're still alive, then you have to pay rent in order to make this work. So there's a lot of reasons for it. It started out for inheritance tax purposes because it reduced the value of the property. But you got to be careful because sometimes people think their kids are going to be real nice at the end of the term. And the kids just might decide you need to go to a retirement home because you don't even own that home anyway. And then you get ejected out of your own house. Domestic asset protection trusts, these are where you go out of state and these states have laws where it says self-settled trust, the beneficiary and the settlor are the same after a certain time, or asset protection. I'm not going to spend a lot of detail on it. Foreign asset protection trusts, they're usually used for keeping creditors at bay, and they're tax neutral. They have quite a cost to them, maybe $35,000 to set up, and maybe $10,000 a year. But for some cases, it's for privacy and asset protection, but it is not a tax dodge. Now this is a fun one, a pet trust. Please don't pet my trust. No, you have a loved animal and you want to create a trust, and here's the code section for California. You can have a pet trust. You put the money in. One thing in your trust, though, that I would suggest if you do a pet trust is, say the money, $2 million goes for my pet until the pet dies. So what you want to put in there that the pet dies of natural causes, because there was a case where the son beneficiary thought that the dog was so depressed, they took him to the vet to be euthanized, and defeated the whole purpose. And they said, well, yeah, but that's why you want the pet to die of natural causes. And Michael Jackson and his pet monkey has a pet trust in Florida. Business trusts, you can have a trust instead of a legal entity. There's several ways that could happen. Deed of trust, now most people think that this is a trust. Well, it is. It's when you borrow on your house. You get a loan and you get a deed of trust recorded on your title. What happens is you give the trustee the bare legal title, the bank's the beneficiary. And the only reason I'm bringing up how a deed of trust works is for this. The reverse mortgage. Reverse mortgages are so bad that the United States Housing and Urban Development Department and California Department and statute require that the homeowner go to a mandatory reverse mortgage counseling class. I don't like them. They destroy your estate plans. For example, and people don't realize it, that's why the required course to learn about it. So you don't realize it, but when you die, your loan is accelerated. So now it's all due. And maybe your kids want the house. Another thing is that if you move out of your home and go to a retirement home and you want to keep the house, you have the right to do that. It's your house. After so many months, they call your loan. And now you've got these high care facility costs, and then you can't refinance a house, so you lose it. They're horrible. And, you know, they're sold to people saying, oh, you get guaranteed income. Well, you're getting your own income back. I really dislike them. I don't think they're fair to the consumer. Other examples of trust benefit, bankruptcy is a trust. They take away the management from the owners. There's a certain type of statutory business trust. Land trust, rabbi trusts are kind of like an unqualified retirement plan. A funeral trust, pooled income fund. It's like you have conservative investments, and this group is handling the investment management for various trusts. Constructive trust, I've gotten these. This is where somebody did something so bad that the court feels that they really owe whatever they stole back to the person they stole it from. So it's constructive, means the court imposed it. Spendthrift trust, most of our trusts are spendthrift, which you don't want the beneficiaries going down to the pawn shop and hawking their beneficiary statements or selling it to some third party. So they cannot assign their interest to the trust. A Totten trust is a trust you have with a bank that says on my death it goes to named beneficiaries. This one has to do with inheritance tax. What's this one? Land trust, personal property trust, not big deals. Nominee trust and anonymity trust. We usually don't use the individual's name on the trust, so it does not show on the title. And if they're really concerned about privacy, they won't be listed as a trustee at that time either. And it's done a lot in Hollywood. People would, don't want the paparazzi coming around. And but you don't have to have a trust in your own name that everybody does. I already mentioned these kind of trusts. So I wanted to say that there is a lot of material here, and I went over the more complicated stuff rather fast. I don't think it's possible in one sitting in 1 hour to absorb this. It's way too much. In fact, the first exposure that I had to this, I went to an all-day seminar in Las Vegas, and I didn't understand a word the guy said. But later I started getting the vocabulary. But you have the handout, and you can go back through. You can also contact us. Our follow-up phone number is 925-934-6320. We have it listed there. Or you could send us an email at rexcrandell@astound.net. And we'll be happy to talk with you about questions you might have. And we're not talking about charging on a phone or anything. But, attendees can maybe clarify something. So if we didn't get it to your answer, we can, we're not going anywhere. And we also offer services in Spanish if you have Spanish-speaking people. So I want to thank you all for allowing me into your home this evening, and I hope it was beneficial for you. And I wanted to say that I could probably talk about this stuff for 4 or 5 hours, but time's up. So thanks for attending.